Today we're here with Stewart Rhodes, the founder of Oath Keepers. Now, Stewart served in the military as a U.S. Army paratrooper. He's an award-winning scholar who's taught military history at Yale, and he's currently writing a book on the dangers of applying the laws of war on the American people. His website is oathkeepers.org. Now, a lot of people in the audience are probably familiar with Oath Keepers, but for those who aren't, could you take a moment to clarify to everyone what Oath Keepers is, what you stand for, and what you're working to achieve?
Real quick, what we are is an association of both current serving and former military, police, and emergency personnel, such as firefighters. And the main focus of the organization is all of those who swore an oath to support and defend the Constitution, who are at the tip of the spear, and who may be given orders to carry out unlawful orders, unconstitutional orders. Our mission is to teach them about the Constitution they swore an oath to defend, and also to reach out to the veterans as well. So those who are former have a responsibility under their oath and under their obligations as citizens to defend the Constitution.
The Oath Keepers has taken an official stance against the recent NDAA bill. But there's a lot of people out there who seem convinced that the NDAA doesn't apply to American citizens, or it doesn't preclude the right to a trial by jury. Could you take a few moments to clarify this for people?
Well, I mean, the background of this is that back when I was a student at Yale Law School, I wrote a paper on just this topic, on the application of the laws of war to American citizens. And I could see this coming a long time ago, because this is not like out of left field. This is not something new. So this is the important background. Is what this bill is saying is that they're affirming the authority they gave, or they claim they gave, back in 2001, right after 9/11, was the authorization for use of military force, which read that the president was authorized to use military force against any nation, any organization, or persons that he determined had anything to do with 9/11 or was aiding those that had. And so that's in 2001. And using that authorization, that's the partial justification for both wars, the war in Iraq and Afghanistan, and everything else the Bush administration did, which included detaining 2 U.S. citizens as unlawful combatants and detaining them in military brigs without a grand jury indictment, without trial. And so that was all, at least in part, justified by the congressional authorization for use of military force. And the reason I say in part is because the Bush administration always asserted that he has an independent power as commander-in-chief to do what he wants and does not need congressional authorization. But the point is that Congress gave that authorization, at least for military force. But since that, almost immediately, it was broadened out and interpreted as meaning not just military force, but also military detention, military trial, and rendition to foreign countries. And he began to do that. He used the full spectrum of war powers. In wartime against an enemy, like, say, against the Japanese or Germans in World War II, you can use military force, you can kill them, you can detain them under the laws of war for the duration of the conflict as a POW, and you can also try them for violations of the laws of war. Like we tried the Nazi war criminals at Nuremberg, or we tried Japanese generals who had committed atrocities. So that's the full spectrum of power under war. And so even though Congress only said use of force, the Bush administration interpreted that as opening up the window to do everything else. And they interpreted that as meaning they can do it to U.S. citizens, and they did. They detained 2 U.S. citizens as unlawful combatants, Yasser Hamdi and Jose Padilla. And here's the thing, this is important background to understand what the NDAA does, is that the Supreme Court, and also the Fourth Circuit in the Padilla case, but the Supreme Court in the 2004 Hamdi case interpreted the congressional authorization of force of 2001 as authorizing military detention of U.S. citizens. And that was one of the arguments. The ACLU and other groups argued that no, it didn't authorize detention of U.S. citizens, and the court said, well, yes, it does. It says any person that he determines had anything to do with 9/11. He can use military force, and if he can use military force, the reasoning goes, he can also just detain. So that's the interpretation that's already been given to Congress's authorization, is that it does apply to U.S. citizens. And so that's why when people say, well, the NDAA doesn't apply to U.S. citizens, it's like, look, guys, they've already interpreted Congress as authorizing detention of U.S. citizens. So what does the NDAA do? Well, Congress says in the NDAA of 2012 that we hereby affirm that under the 2001 authorization for use of military force, they affirm that authorization includes the authority for the armed forces of the United States to detain covered persons, as defined, in subsection B, pending disposition under the laws of war. And the covered persons, it repeats a lot of the same language of the 2001 authorization. Those had anything to do with, September 11th or harbored those responsible. But then it adds on another category, a person who was a part of or substantially supported Al-Qaeda, the Taliban, or associated forces that are engaged in hostilities against the United States or its coalition partners, including any person who has committed a belligerent act or has already supported such hostilities in aid of such enemy forces. So they do broaden the supposed category of people this is going to apply to. And the reason why I say supposed is because they always go far beyond. Even this whatever's written down, it's always expanded beyond that. So, but the main thing that this does, that's different, is that it includes a subsection C. It says disposition under the law of war. It says the disposition of a person under the law of war as described in subsection A may include the following. And this is new, first time in writing that Congress has authorized: 1, detention under the law of war without trial until the end of the hostilities authorized by the Authorization for Use of Military Force. 2, trial under Chapter 47A of Title 10 United States Code as amended by the Military Commissions Act of 2009. What this means is military trial. And 3, transfer for trial by an alternative court or competent tribunal having lawful jurisdiction. And then it says 4, transfer to the custody or control of the person's country of origin, any other foreign country, or any other foreign entity. And so what this really is that Congress is putting in writing for the first time the full spectrum of claimed powers that the president can use in wartime. They're putting in writing what the Bush administration and the Obama administration has already interpreted the 2001 authorization to authorize. So Congress is just kind of saying, yes, we meant that. We meant that, yes, he can use detention, he can use military trial, and he can even use extraordinary rendition, and we agree that it can be applied to any person. It says any person. And if you go back to the 2001 declaration, any person he decides. And so, and they're doing this with the knowledge that President Bush has already interpreted this power as applying to citizens, that the court has already backed him up on that and interpreted the consent of Congress to detain American citizens. And one more thing is adding on that they're doing this with the knowledge that President Obama has already begun to kill American citizens. His interpretation of his authorization to use military force includes using military force to targeted killings, assassinations of American citizens that he considered to be unlawful enemies under the laws of war. And that's the big point people need to understand, is this is not normal criminal law or normal law under federal statutes. This is the law of war. The claim is that your citizenship or your lawful residency is irrelevant, and the American people can be treated exactly the same as if you were in Iraq or Afghanistan. If you're a goat herder in Iraq or a goat herder in Afghanistan, if you are accused of a normal crime like stealing your neighbor's goat, you'll get a normal trial in the trial, whatever they give you in Iraq or in Afghanistan. But if the U.S. military thinks you're part of the insurgency or you're aiding the insurgency, what happens to you? They just come pick you up. There's no requirement that an Afghan court approve of that first. They just come get you. This is the same claim that they can step outside of normal law, outside of the Constitution, outside of the Bill of Rights. You don't get a grand jury indictment. You don't get a jury trial. None of that is necessary. They just come and get you and then take you into military jurisdiction exactly as if you were a foreign enemy in wartime. That is what this is doing. That's what they've been doing since 2001. This just says that's okay. But the sleight of hand that Congress has done is they say, well, nothing herein shall be interpreted as expanding the powers of the president. But the thing is what they're saying is that, hey, we meant this back in 2001. So we're just affirming that we gave this authorization back then. So that's why they can say we're not changing anything, because they already gave the authorization in 2001. That's kind of like the legal fiction and a little pretend thing. Let's pretend like we meant all of this back in 2001, even though we didn't write this back then, we're writing it now. That's the little sleight of hand that they're playing. And then they also say, well, nothing herein should be interpreted as affecting the current laws and authorities related to detention of U.S. citizens and lawful residents. Same thing. They have already interpreted the current laws and authorities as being, wide open, allowing the president to use the full panoply of force against American citizens. And so that also doesn't help you. See what I'm saying, guys? It's like, they're telling you that way back in 2001, they meant all of this with the knowledge that it has been interpreted to allow detention and also target assassination of Americans. And what they're really making clear for the first time is that it also includes trial, military trial, and it also includes extraordinary rendition. They're telling you that they are giving the president the power to turn you over to foreign nations or any other foreign entity. That's what they're telling you.
There's a lot of people who would listen to this and say, well, even if they take me to a military court, I'm going to get a chance to prove my innocence. But really, from what I can gather, it seems that they've set this up so that all it takes is an accusation by the president, and you can be killed or made to disappear without any real due process.
It's not even an accusation. It's a designation. He designates you an unlawful belligerent. So it's not like he accuses you, because that presumes you're going to have an opportunity to defend yourself, and he has to prove it, right? No, he just designates you. He says you are. When she says you are an unlawful belligerent, like he did with Jorge Videla or Yasser Hamdi, then he just has you detained in military custody. And once you're in that system, and unfortunately the Supreme Court in 2001 in the Hamdi case said this is okay, once you're in that system, at the very most, you're going to get, yes, you can have a habeas petition challenge, but that's not going to ask them, well, under what law are they holding you? Has there been a grand jury indictment? When are you set for trial? That's normal habeas review. This is saying, well, okay, you get a chance to challenge your designation as an unlawful belligerent under the laws of war. And so the court will, at the most, give you a chance to tell a judge, a federal judge, I'm not a belligerent. And then the federal judge will say, well, let's hear what the government has to say. And then they present, evidence. It could just be a minimal standard of some evidence. They submit some evidence that you are an enemy belligerent, and then the federal judge affirms your detention. That's what happened to Jorge Videla. That happened to him in the Second Circuit, and then when he got transferred to the Fourth Circuit, it happened to them again. So it's not like they're going to have to, put you on trial. You're going to get at most a judge saying, well, I find the government does have some evidence that you are an enemy belligerent, and then you stay in that military system. And in fact, in 1024 of the NDAA of 2012, it tells you there that status determinations will be done by a military judge. So at the very most, under this system, once the president points his finger at you and says you are an unlawful belligerent, he can have you taken to Guantanamo or any other military installation and detained indefinitely for the duration of the war. And at the very most, what you're going to get is a supposed chance to go before a military judge and argue that you're not an enemy combatant, an unlawful belligerent. And so, but that's not our constitutional system. The Constitution requires, it's first of all in Article 3, Section 2, it says that all crimes except for impeachment shall be tried by jury. And then immediately after that, it defines, Article 3, Section 3, it defines the crime of treason. Treason shall be only making war against the United States, levying war against the United States, or aiding and abetting its enemies, giving them aid and comfort. That is what treason is. And that is exactly what this statute is claiming to reach at Americans who are accused of being part of the enemy, part of Al-Qaeda or the Taliban or associated forces, or who are accused of aiding those forces. But instead of giving you a trial, which is what you're supposed to get, a trial for treason, they're sidestepping that requirement, and they're instead giving you a military trial. So it's the plainest constitutional provision that's directly on point is the Treason Clause. Article 3, Section 3 defines the crime of treason as just that, making war against the United States or aiding its enemies, and it says that it requires two witnesses to the Overt Act, two witnesses, extra procedural protections, or confession in open court. And so the founders defined, that's the only place you're going to find in the Constitution a crime defined. They defined the crime of treason, and they gave you all the elements for it, and they said that before you can take away someone's life or liberty after accusing them of being a traitor, you must have two witnesses to the same overt act or confession in open court. And what they were worried about was secret confessions or torture. They were worried about torture and coerced confessions, and they were worried about secret evidence and secret accusers. You had to have two witnesses, and so they provided extra protections. And of course, this is all in a jury trial, a public jury trial in a civilian court. And so this is the plainest provision you can find in the Constitution that tells you exactly what must be done with an American accused of committing treason, making war against their own country, or aiding the enemy. And yet they've sidestepped this. And they've sidestepped, along with that, the Fourth Amendment, the Fifth Amendment, and the Sixth Amendment, which tells you also what must be done with an American accused of any kind of crime. There's a requirement that they get a warrant. There's a requirement that they have a grand jury indictment. There's a requirement that they have a jury trial where they can take your life or liberty. They're sidestepping all of that because under our system, the government can't take your life away from you or your freedom. Only a jury of your peers can do that. So only the people themselves. That's the whole point of a jury trial. But they sidestep that and doing it through the laws of war. They're saying, well, under the laws of war, your citizenship's irrelevant. Under the laws of war, you don't get a normal jury trial. You only get a military trial. And so they've taken the laws of war that apply to foreigners, and they're applying them to U.S. citizen and lawful residents and tearing down that wall of separation of what can be done in wartime to a foreign enemy and what can be done to our own people. There's no grant of power in our Constitution for Congress to declare war on the American people or for the President to wage war on the American people. It's not there. If it had been there, you can bet that the anti-federalists like George Mason or the opponents of the Constitution like George Mason or Patrick Henry would have pointed it out, that had been riddling to the high heavens about this dictatorial power, but it's not there. They've created it. It's a legal fiction they've created out of the international laws of war, and they pretend like that can be applied to Americans. And what they've done is create a second legal track, which is pretty much the same kind of second legal track that you saw in Nazi Germany or in Stalinist Russia, where political opponents of the regime can be taken down and the laws of war applied to them.
Considering that these powers were basically created out of an expansion of the 2001 laws, do you look at this as just a stepping stone towards an even greater expansion of these powers, to where they even could remove those definitions regarding who they are said to apply to?
Those definitions are meaningless. I mean, look, here's the thing, is that consistently all through since 2001, both Bush and Obama have asserted an independent authority as commander-in-chief under the Article 2 powers of war for the commander-in-chief to just do this on their own. So their argument is consistently they don't need congressional approval. So that's one thing to think about. The other thing to think about is that when Congress authorized the authorization of use of military force in 2001, it was already taken way beyond just the narrow definition. They didn't just go after people directly connected to 9/11. Obviously, they went after Saddam Hussein. They went after anybody who's an insurgency in Iraq. They went after, other people. So they're already going to go way beyond and broaden it. And the other thing to think about, though, is even if they stuck to those narrow definitions of, say, even if they just said only we're going to go, use this war power against Al Qaeda. Well, who says who's in Al Qaeda? Well, the president says who's in Al Qaeda. He can point his finger at you and say Aaron is in Al Qaeda, and they'll say, well, the president has as the power as commander-in-chief to make that determination that Aaron is Al-Qaeda. And once they've made that determination, you're in that military system. So it's kind of like the laws against murder, right? You're secure against a law against murder, not because not just because you're not a murderer, but you're also secure. You don't feel too threatened by it because before they can convict you of being a murderer, they have to put you on trial. There has to be a grand jury indictment before they can even prosecute you. So that's the first step. As a panel of your fellow citizens must decide that, yes, there's enough evidence to go forward to prosecute you. And then the next step is they got to go through a jury trial to prove you guilty beyond a reasonable doubt. So, and in front of a jury of your peers. That's why you're pretty safe against being just called and accused of being a murderer. Now, imagine if the president could just point his finger at you and say, you are a murderer. Aaron is a murderer. I don't have to put him on trial. I just designate him as a murderer. And now I'd hold him for, forever. Or I can try him in front of some little handpicked panel of military officers to put him on trial for the crime of being a murderer. Now, would you feel safe? No. be the same as living under Nazi Germany or in Stalinist Russia with the show trials in Russia. In Germany, they called them the people's courts. They were special courts packed with Nazis, and you didn't get the normal due process of a criminal. You got shuffled in front of this special Nazi court, which was a total kangaroo court. And then they'd find you guilty, and then they'd execute you. Or you wouldn't even get a trial. You would just get sent off to the concentration camps. Same in Stalinist Russia. A lot of those folks didn't get trials. They just got sent to the gulag. Same thing here. He can just point his finger at you and say, you are an enemy of the state. Of course, he'll just call you Al-Qaeda or an associated group, maybe American Al-Qaeda or white Al-Qaeda, whatever they're going to call you. And then he just says, you are an enemy, and they take you off to the camps. There is no difference. The only difference here is that, well, yes, you might get a chance to go before some military judge, but what's the military judge going to do? He's not going to demand a burden of proof or beyond a reasonable doubt. You probably won't even get a chance to confront your accusers. It'll be a minimal some evidence standard. That's what's been used so far. So long as the government presents some evidence to justify this designation, the military judge will accept it.
So what would you say to the men and women out there who are currently serving, who want to honor their oath? They see this, they see what's coming, and they're scared. They fear the repercussions for standing up, but they want to do something. And because these people are contacting me, I have men who are reaching out to me and saying, I agree with what you're saying. I agree with the Oath Keeper concept, even if these people aren't necessarily saying Oath Keepers. What can they do in a practical way?
Well, the first thing is that they need to look inside themselves and remember that when they raised their hand, took that oath, that was an irrevocable step. They stepped through. It's like crossing a line. Once they crossed over that line and took that oath, now they no longer have an option of ducking out. They cannot violate their oath. They must do what they said they would do. So it's, if they're willing to, and they were, if you're willing to go into combat and die for your country, I served as a paratrooper. I was perfectly willing to do that, and everybody else is feel the same way. If you're willing to die for your country to fight a foreign enemy, you have to have the same resolve to be willing to die or lose your freedom in order to keep your oath and protect the freedom of the American people. That's the whole point. The whole point of the Constitution is to defend our freedoms. That's what it's for. And if you violate your oath, it'd be the same thing as turning traitor and fighting for a foreign enemy. If you violate your oath when given an unlawful order that violates the rights of the people, then you're no different than a traitor who fights for a foreign enemy. That's why it says against all enemies, foreign and domestic. So that's the first thing, is you got to just get your head right when it comes to what you're willing to do and what you're willing to suffer to do to keep your oath. If you have the courage, and you do, to die in combat, you have to say, okay, I'm going to take the same resolution, the same resolve, the same willingness, and I'm going to apply that to being willing to suffer the consequences when I stand up for what's right and refuse unlawful orders. It's just like look at My Lai, the My Lai massacre during Vietnam. You had Lieutenant Calley, who defended himself by saying he was the one in charge of the platoon that was murdering women and children, and he said, "Well, I was just following orders. There was no defense." And then you had Warrant Officer Thompson on the other side of that in that event, who came in and with his choppers, and he stopped the massacre, and he stopped it in large part by putting himself directly in between the victims and the guys who had gone over the deep end. He got off his chopper and he went in there and got women and children and brought them back to his chopper, and he told his crew, he said, "Look, if they start to fire on me or shoot any more women and children, I want you to turn the machine guns on the choppers against them," is what he told his crew. So there's a good example of a guy who was willing to die to do what was right to protect innocent people. And so that should be your model for what you're willing to do as far as, putting yourself at risk. Because otherwise, what are you? Either you defend the people and their rights, or you don't. If you don't, after taking that oath, then what you become is an oath breaker. And to the founders, that was a serious. It was like renouncing God. It was like renouncing everything you ever stood for. It's a very serious thing to intentionally violate an oath. So that's the first thing, is you got to be ready for that mentally and spiritually. Get your head right. And the next thing is that, yes, you may have to do it as an individual, just like Michael New refused to serve under UN command as an individual. And I can't guarantee it's going to turn out good for you. It didn't turn out well for him. He was court-martialed in a kangaroo farce of a court trial, and he was found, guilty of insubordination. But he kept his honor. He did the right thing. But a better way to go, if you can, is to have your whole unit stand down and do even a preemptive refusal. Get together and talk with each other. And a good model for that is on our website. We have a video there of an interview with Staff Sergeant Joshua May from the Utah National Guard. And during Hurricane Katrina, when they went down there and were deployed during Katrina into New Orleans, they had heard in advance about the gun confiscation that was going on in New Orleans. And they got together and talked among themselves, the men did, and they decided that they're not going to do that. And so even the officers asked Sergeant Joshua May, because he was, kind of like the resident constitutionalist in the unit. They asked him to go to the commander and tell the commander, sir, we've talked about this. We heard about these orders coming down, and we just want to let you know that we will not do this. So, if we're given these orders, we will refuse to comply. And his commander said, well, hold on, let me go talk to Big Army and see what's going on. And the word came back down, don't worry, you will not be asked to do that. And so you can look at that as a situation where, Big Army blinked. They didn't insist that these guys do this. There was no command formation. There was no dress down. There was no discipline whatsoever. And I think a big element of that is that the whole unit did it. So when the whole unit steps up, what are they going to do? They're going to court-martial an entire unit? If they did, that would further tear the mask off and show the rest of the military just what they're dealing with, which is absolutely illegitimate. I mean, guys, go read the Treason Clause. That is as plain as a nose on your face. In fact, I can't think of a more absurd example of a direct violation of the plainest text of the Constitution than the claim that a person who is accused of those elements, those activities which constitute the crime of treason, that they can be stripped out from under the Treason Clause and its requirements and under the protection of the Bill of Rights, and instead tried the same as a foreign enemy. It's just absurd. So, but talk among yourselves and each other about this. I would encourage you to go to oathkeepers.org, and we'll be doing more updates on NDAA. I'm helping to write draft resolutions for state legislators, for sheriffs, for counties, on down the line. A team of good lawyers getting together to write this stuff up, and we'll be having, I'll give you all the ammunition you need to understand why this is so unconstitutional and so dangerous, and to be able to teach your fellow soldiers and airmen and Marines and Navy guys about why this is wrong. And then once you disseminate that through your units, you're going to have to make a decision. And I would encourage you to try to do it as a unit. Yes, there can be downsides of that. There can be downsides to a preemptive refusal. You could be purged possibly out of your unit. But once again, if a whole unit gets together and does a preemptive refusal, and then they purge all the guys and they send you all off to desk duty somewhere and there's reprisals against you, once again that will help to tear that mask off and show the rest of the military exactly what we're dealing with. But it is time.
Speaking of treason, in real legal terms, would you say that the Congress has committed a literal act of treason by passing this law?
I would say that as far as knowingly doing it, I would say that certainly yes. When it comes to John McCain, Lindsey Graham, Carl Levin, these are people that, especially John McCain and Lindsey Graham, who are both military officers, they understand exactly what they're doing. So I would say yes, because treason, remember again, treason is defined as levying war against the United States. And what they have done is to say that by authorizing the president to use military force, including killing you, military detention, military trial, or extraordinary rendition against U.S. citizens and lawful residents, by authorizing that, that is, I mean, what else is that except levying war against you? So yes, I think they are guilty of treason, and I think they should be, arrested and indicted and tried for it, and then once they're found guilty, they should suffer the proper sentence. So I think there's, the rest of them, I guess we can find out whether they knowingly did this or whether they're just useful idiots. So I think a lot of people in Congress just weren't paying enough attention, weren't reading the bill, didn't really understand what they were doing, but I think some of them do. So I think so it's a qualified yes. I think some of them definitely are because they knew what they were doing, but others, you could say, are just unwitting. But either way, they don't deserve to be in public office anymore. They should be removed. I don't think any person that voted for this is either a willful traitor or is a useful idiot and doesn't understand the Constitution. They got to go. They need to be kicked out of office.
So do you have any final thoughts you'd like to share with the police and the military and the American people in general?
Well, I mean, I encourage people. Well, here, first of all, this is a very serious crossroads. I just got back from Kansas where I interviewed a woman who had lived in Nazi Germany as a young girl, and also a gentleman who lived in the Soviet Union, and they both told me the exact same thing, that they see what's happening in the United States right now is the exact same thing that they saw in Nazi Germany and in the Soviet Union, in which they left, and then they're both scared and very angry to see this happening to their new adopted country. So that's the first thing, is that we're at a crossroads. If we don't put the brakes on and don't fix this, we're going to slide into Nazi Germany, like the Fourth Reich. We're going to become the new version of Nazi Germany, and that's no joke. We are there. It's like 1933, 34 Germany. That's where we are. So we can, if we don't stop this, we're going to have to either slide into that and lose all our freedom, or we'll have to fight another revolution. It'll be like so it'll be like a choice between 1934 Germany or 1774 America. Which one is it? So, but I think the last chance we have of a peaceful restoration of the Constitution and a peaceful putting the brakes on and stopping this nonsense is a modern version of what Jefferson and Madison did in 1800, what they call the Revolution of 1800. In reaction to the Alien Sedition Acts of 1798, what they did is they pretty much criminalized free speech. The Alien Sedition Acts allowed the government to put people in prison. Newspaper editors and writers and anybody who spoke out against the president was a violation of the First Amendment. Very blatant and plain, but yet they still did it. The Federalists did it. They crammed that through Congress, and they started arresting people. Well, the response of Jefferson and Madison shows us the proper course. They did two things at the same time. First, they went to the state legislatures and said, you have a responsibility to declare this null and void. They didn't go to the Supreme Court. They didn't go to the federal courts. They went to the state legislatures and said, you have a duty to declare this null and void, which it is from inception. It's unconstitutional, it's null and void, and you have a duty to interdict and interpose yourself between this unconstitutional, illegitimate power and the people of your state. That's the first thing they did. The second thing they did is they swept out all of the oath breakers, all of the Federalists that voted for this atrocious violation of the First Amendment were swept out of public office. So Jefferson and Madison formed a new political party. Jefferson led that party to victory. Jefferson became the president, and they cleaned Congress out at the same time. But they did those two things together at once. They nullified in the states, and they swept them out politically. So that is what we have to try to do, is those two things at one time. Nullify. And I mean nullify as individuals, nullify as towns, as counties, as sheriff departments, as police departments, as states, as the National Guard of that state should nullify, should say this is illegitimate and void from inception, and we will not carry this out. And we should also nullify. That's why I tell the military, you've got to nullify too. You've got to look at this and go, okay, I have a responsibility as an oath-sworn officer or oath-sworn NCO or enlisted man. I have an obligation and duty to say this is an unlawful order I will not follow. Okay? You can't follow it. So in a way, even the word nullification is not really proper, because you're not making it null and void. It's null and void from the inception because it doesn't comply with the Constitution. Any law, I don't care, Congress, all of Congress can pass it. The president can sign it. The courts can say it's okay. But if it violates the Constitution, it is null and void from inception. And you have a responsibility, just like the states have a responsibility, to even stand up to the federal courts when they get it wrong. I mean, the federal courts got it wrong in Dred Scott. They got it wrong in Korematsu in World War II. They said that you can intern Japanese Americans. They got it wrong in Plessy versus Ferguson. Where they said that separate but equal is okay. You can have to put black people to the back of the train or the back of the bus, and that's somehow equal protection. That's nonsense. But they did that. It still doesn't make it right. It's still a violation of the Constitution, even if the court says so. Just like in Schenck, the case in World War I, where you had an anti-war protester who was arrested, and the court said, well, free speech that would be tolerated in peacetime will not be tolerated so long as men fight. So during wartime, you can arrest an anti-war protester for his speech. And where's that in the Constitution? It's not there. They just made it up. This is the same kind of garbage. The court is making up garbage to justify giving the president the authority to treat you the same as an Iraqi goat herder. You have to say it's null and void from inception. We don't care what the damn federal courts say. Remember, our forefathers, they fought a revolution against a government that did almost exactly the same kinds of things. If you go read the Declaration of Independence, one of the charges against the king is for depriving us in many cases of the benefit of trial by jury. Another one was for transporting us beyond seas to be tried for pretend offenses. That was the extraordinary rendition of their day. Another one is he is affected to render the military independent of and superior to the civil powers. So these are the reasons why they fought. Yeah. And these same things are now being done by the current government in the United States. History is repeating itself. So the point is that we have to stand up as a people and use civil disobedience, massive civil disobedience at every level against this. And at the same time, we've got to sweep out all those bums, all the oath breakers. And I don't care what party they're in. It's not about left or right. It's about the Bill of Rights. Yeah. And so you got to set aside party. Forget about party. I don't care. They always use the argument of lesser of two evils. Well, if we don't get behind, the Republicans and the Democrats get back in, that kind of thing. I don't care, because if you're taking a reduced dose of poison, you're still poisoning yourself. And that's how we got to where we are right now. Both sides do it. They turn a blind eye to their own party, whether it's Democrat or Republican, because they're afraid of the opponents. And they go ahead and look at the last election. What was our choice? Yeah. John McCain or Barack Obama? John McCain is the guy who just wrote the NDAA. Yeah. And Barack Obama is the guy who's running around right now killing American citizens. So this is why you wind up with those kinds of choices, is because people put party in front of principle. So stop doing that. Stop compromising on the Constitution. You don't have another chance, people. This is your last chance. If you don't get it right this time, and for once set aside nonsense differences about political lines and get together and defend the Bill of Rights, if you don't do that, this country will either be destroyed or will be forced to fight another revolution. Take your pick. One last comment I want to make is another example to go look at in history is 1989 East Germany, when the wall fell. What you had there is massive civil disobedience, massive demonstrations for a whole year leading up to the November confrontation. What happened there is that the people were getting in the streets, and they were peaceful, massive civil disobedience, which I definitely recommend. But then what happened is the Communist Party at the end there panicked and said, "Oh, we got to stop this." And so they finally ordered the military to go crush the protest, to stomp out the protest. And the commander of the East German military refused to do it. He said, "No, we're going to stay on base. All of my men are going to stay on base. No units are going to be used against the people." And without the support of the military, 2 days later the wall fell.
Excellent point.
Because without the support of the military, the Stasi secret police, who were so feared, the Communist Party, which was so bloodthirsty, they couldn't do anything without the support of the military. The secret police were running and hiding, tearing off their insignia and trying to pretend like they were normal cops or normal military, and they were being hunted down and arrested by the people. So that was a very peaceful revolution, which was possible because the people maintained a peaceful civil disobedience, but that was combined with a mass stand down by the military. If the military does stand down like that, it can be peaceful. But if the military does not stand down like that, then it cannot be peaceful. It's very difficult to have a peaceful resolution, whether you call it a restoration or a revolution or whatever you want to call it. It's in the hands of the military to determine whether it's going to be peaceful or not. It really is. Because if the military does the right thing, it can go like that. It can go like East Germany in 1989. If the military does the wrong thing, then it could be very bloody. So, we hope to stop it from ever having to get there. That's why I encourage people to step up and nullify and use civil disobedience, but also use your political process. Look, it's a narrowing window of opportunity. I don't discount the fact that elections are corrupt, that the party machine system, the two-party machine system, is very corrupt, and with gerrymandering and all that, it's very difficult to get them out of office. I understand that, but we have to at least try so that we maintain the moral high ground and say we did everything we could. But the military should definitely be preparing itself for the prospect of a mass stand down, because that is going to be the last peaceful fallback. If they obey unlawful orders and begin to round up Americans and black bag them, I can tell you right now, I'm talking to veterans across this country, that if active duty military starts to use military force and detention against U.S. citizens here in the United States and start rounding up veterans, for example, then other veterans are not going to wait. They're not going to just sit in their house and wait for you to come to the door. They're going to go live. They're going to go active. They're going to go after, who they think are responsible. So, don't open that door. That's the important thing for the military and police to understand, is that by you refusing to follow such orders, you buy the people more time to solve this peacefully. If you start to enforce this kind of oppression on your own people, then you don't give the people much option. You tighten the time frame and you force them to start to defend themselves. What are they going to do? So, it's in your hands. Which course it goes is in your hands.